Welcome, curious minds, to another deep dive. Ever wondered about those invisible legal threads that connect us? Today, we're pulling back the curtain on two big ideas in civil law that often get tangled up: the law of contract and the tort of negligence. You might think, well, they sound similar, and in some ways, they both deal with obligations, what happens when things go wrong. But understanding their differences, the real nuances, is absolutely key. Our mission today, using insights from an article looking at key aspects of both, is to unravel this. We want to illuminate the crucial differences, but also maybe some surprising similarities too.
Indeed. And it's interesting because they both fit under this big heading, the law of obligations. But, despite sharing some common ground, like in both, the claimant sues the defendant, needs to prove their case on the balance of probabilities.
Meaning more likely than not.
Exactly. More likely than not. And remedies usually aim to compensate, not punish, and they're limited by how sort of remote the loss is. Despite all that, the core ideas behind them really diverge quite significantly.
Okay, so let's get into that. Let's unpack this first big difference. How the parties involved actually, relate to each other in contract versus negligence. In a contract, it feels pretty straightforward. It's about agreeing to something together, right?
So, absolutely. A contract is basically a legally binding deal made because both sides consent. Doesn't matter if they know each other well, like, say, an accountant and their client, or if they're strangers, like a software company, and, you clicking, I agree. The key is the relationship is formed by the contract, and it's governed by the terms in that contract.
Okay, so the contract actually creates the link. What about negligence then? Where does the relationship come from there? Because there's no upfront agreement.
Right, and that's a fundamental split. Negligence cases are built on a non-contractual relationship. The parties might know each other as surgeon and patient, for example.
Sure.
Or they could be total strangers, like two drivers in an accident. Because there's no pre-existing agreement setting out the rules, the very first thing a claimant has to do in a negligence case is prove that the defendant owed them a duty of care.
The duty of care. And this is where things like professional negligence come in, isn't it? Really relevant if you're in certain professions.
Precisely. There was a really important case involving auditors and shareholders. Shareholders relied on audited accounts, bought more shares, then found out the company wasn't profitable after all. The crucial point the court made was that the auditor's contract was with the company, not individual shareholders buying more shares or potential investors.
Okay.
So the court set out this sort of three-part test for when a duty might exist in new situations. Was the harm reasonably foreseeable? Is there enough closeness or proximity between the parties? And importantly, is it fair, just, and reasonable to impose that duty? In that specific auditor case, the court said, well, yes, a duty was owed to the shareholders as a group, but not to those individuals acting as investors based on the accounts.
Wow. So even if they relied on the info and it was foreseeable, they might.
Exactly. No specific duty was found for them in that context. It really shows how critical establishing that duty is right at the start in negligence. Without it, the case just doesn't get off the ground.
Okay. And this links to that idea of a special relationship too, especially with professional advice.
It does, yeah. That came up in an earlier case involving an advertising agency asking a bank for a credit reference about a client. There was no contract between the agency and the bank. Now, the bank got off the hook because of a disclaimer they'd put in.
The small print.
Always read the small print. But the court said without that disclaimer, the bank would have been liable. Why? Because the bank used its special skill to provide information, knowing the agency would rely on it. That created the necessary special relationship, that non-contractual link.
Fascinating. So we've got how the relationship starts. Contract through agreement, negligence through a legally imposed duty, sometimes needing a special relationship. Now, once that link exists, what is the obligation? What's its nature? In contract, it's about what you signed up for, isn't it?
Spot on. In a contract, the duties are basically set by the terms you agreed to. By entering the contract, you voluntarily accept those specific promises. Now, it's not totally unlimited. Freedom laws exist, like the Unfair Contract Terms Act, that can restrict certain unfair terms, especially for consumers.
Right.
But the fundamental idea is that contractual obligations come from that mutual agreement, that intention to be legally bound.
Okay, agreement is key for contract. What about negligence? If it's not agreed, where does the obligation come from? Is it just imposed?
That's exactly it. In negligence, the obligation isn't agreed upon. It's imposed by law. Think about driving. You automatically owe a duty of care to other road users. You didn't sign anything. It's just part of using the road.
Right. Or a manufacturer making a product.
Same idea. They owe a duty to the people who eventually use that product. And once that duty is established, the question becomes, did the defendant act reasonably? The standard is the famous reasonable man. What would a reasonable person have done?
That old case about the waterworks.
That's the one, yeah. It's at the standard. And for professionals, it's higher the standard of a reasonable professional with that particular skill.
Yeah.
And interestingly, even learners are judged against the standard of someone fully qualified.
No discounts for being new to it then.
Not when it comes to the legal standard of care, no.
Okay. So let's say there's been a breach of contract or a negligent act. Things have gone wrong. How do we link that wrongdoing to the harm that follows? And how far does the responsibility stretch? This gets us into causation and remoteness. Let's take contract first. How far down the chain reaction is the defendant liable?
Yeah, this is about the extent of liability for the consequences.
Yeah.
The classic case here involved a broken mill shaft. A carrier was late delivering it for repair, the mill couldn't operate, and the owner lost profits.
I remember this one.
So the court laid down a two-part test for remoteness in contract. The loss has to be either a normal, predictable result of the breach, something you'd naturally expect, or it has to be something that both parties would have specifically thought about as a probable result of a breach when they made the contract.
So what happened with the mill shaft? Did the owner get the lost profits?
Surprisingly, no. The court said it wasn't a normal result because, well, maybe the mill had a spare shaft. It wasn't guaranteed to shut down.
Right.
And the mill owner hadn't specifically told the carrier, look, if this is late, my entire operation stops. So lost profits were considered too remote under both parts of the test.
Wow. Okay.
There was another case involving a laundry company and a delayed boiler delivery. They recovered their normal lost profits because delay obviously causes some loss of business.
That makes sense.
But they couldn't recover losses from a very lucrative special government contract they missed out on because the boiler company didn't know about that specific contract when they agreed to deliver the boiler.
So in contract, it really comes back to what was reasonably foreseeable or specifically contemplated at the time of the agreement.
Precisely. It's tied to the moment the deal was struck.
How does negligence handle this? Is it just foreseeability again?
It is about foreseeability, yes, but applied a bit differently and often broken down. First, you have causation. The main test here is the but-for test. Would the harm have happened but for the defendant's negligence?
Do you give an example?
Yeah, there's a stark case where a patient was sent home from hospital without being properly examined and later died. The doctor was definitely negligent, breached the duty of care, but the evidence showed the poisoning was so severe the patient would have died anyway, even with prompt treatment.
Wow.
So the doctor's negligence didn't actually cause the death in the but-for sense, so no liability.
Tough outcome. Okay, so that's causation. What about remoteness and negligence?
For remoteness, the key test is basically, was the type of harm suffered reasonably foreseeable? The famous example is the case where oil was negligently spilled into a harbor.
Right, the oil spill.
Later, some welding sparks ignited the oil, causing a big fire that damaged a wharf. The court found the defendants weren't liable for the fire damage. Why? Because while pollution damage from spilling oil was foreseeable,
Sure.
damage by fire wasn't considered a foreseeable type of consequence of that particular spill at that time.
That seems quite strict. Wasn't there another case that seemed a bit broader about a boat?
Ah, yes, a good contrast. The case with the abandoned boat left by the council. Kids played on it, the council knew this. A teenager tried to repair it, it collapsed, and he was badly injured.
And the council was liable.
Yes, they were. Because even though the exact way the injury happened, the boat collapsing during a repair attempt wasn't foreseen, the council did foresee that some kind of physical injury was likely if kids played on a derelict boat.
I see. So there's foreseeability of the general type of harm, not necessarily the exact chain of events.
That seems to be the principle, though you can see how applying it can get tricky in specific cases. And it's worth remembering, negligence uses foreseeability twice. Once for the duty of care itself.
Like in the auditor's case.
Exactly. And then again, for remoteness, if there's no duty in the first place, you don't even get to the remoteness question.
Okay, that makes sense. So we've established liability. We know how far it might reach. Let's talk remedies. The bottom line. What's the goal? And how are damages calculated? And can they be reduced?
Well, interestingly, the fundamental aim in both contract and negligence is pretty much the same. Put the claimant back in the position they would have been in if the wrong hadn't happened.
Making them whole again.
Exactly. Compensation is the primary goal.
But how does that position they would have been in differ between the two?
Good question. For contract, the aim is to put them where they would be if the contract had been performed properly. So damages often cover expectation loss, the profit or benefit they expected to get.
The benefit of the bargain.
Precisely. Or it could be reliance loss, the expenses they incurred relying on the contract being performed. And here's a key point in contract. The claimant has a duty to mitigate their loss.
Meaning they have to try and keep their losses down.
Yes, they have to take reasonable steps to minimize the damage caused by the breach. Think back to that seller whose buyer refuses the goods.
They have to try and sell them elsewhere.
Exactly. If they just sit back and let the losses mount without trying to resell, their damages could be reduced. And it's actually up to the defendant to prove the claimant failed to mitigate reasonably.
Okay, so mitigation in contract. What about negligence? How does making them whole work there, and can damages be reduced?
In negligence, the aim is to put the claimant back where they were if the tort hadn't been committed. So it's about reversing the harm caused by the negligent act. And yes, damages can be reduced here too, but for a slightly different reason. Contributory negligence.
So this is where the claimant themselves is partly to blame for their own injury or loss.
That's exactly it. If the claimant's own carelessness contributed to the harm they suffered, even though the defendant was also negligent, the claimant's damages will be reduced proportionally.
By a percentage.
Yes, by whatever percentage the court thinks the claimant was responsible for their own loss. There's that famous, slightly odd case of the woman trapped in the public toilet.
Oh, yes.
She tried to climb out, fell, and got injured. The court found the counsel negligent for the faulty lock, but reduced her damages because her method of escape was considered unreasonable. She contributed to her own injuries.
So she was partly responsible.
Exactly. And again, the burden is on the defendant to prove the claimant was contributorily negligent.
Right. So wrapping this all up then, what's the big takeaway for you listening? We've gone pretty deep into contract and negligence. They both deal with obligations. They both compensate for loss. But those core differences are really important. How the relationship starts agreement versus imposed duty, what the obligation actually is, specific terms versus a general standard of care, how we determine causation, and how far liability stretches, and even how damages might be reduced.
Absolutely. Understanding these isn't just for lawyers. Contract is about upholding promises, ensuring you get the benefit of the deal you made. Remedies look forward, in a sense, to where you should have been. Negligence is about duties the law imposes to protect people from unreasonable harm, often when there's no prior deal. Remedies look backward, trying to undo the wrong, to restore you to the position you were in before the harm occurred. It's not about one being better, just different tools for different situations.
So think about it. A service you use all the time, maybe your phone provider, your bank, the platform you're listening to this on right now. How might things play out differently if something went wrong, depending on whether it's viewed through the lens of contract or negligence? Could knowing how remoteness works in each area affect how you might approach a problem, or even the agreements you make? Something to ponder. Keep exploring these ideas, because the law of obligations, well, it shapes so much of our daily interactions.